And you are live. Roll call. Senate Minerals, Senator Beitman,
Excused.
Senator Cooper,
Here.
Senator Rothfuss, Senator Wasserberger,
Here.
and Chairman Anderson.
Here. First order of business for the Senate Minerals Committee is Senate File 84, and I believe we still had public comment open from last Friday. Is there any more public comment? Is there anybody on the Zoom? No? Here's some public comment.
Thank you, Mr. Chairman, members of the committee, Shannon Anderson on behalf of Powder River Basin Resource Council. We oppose this bill. Our organization advocates for responsible development of our state's mineral resources. And we believe one of the most important ways that operators can be responsible to our state citizens is by providing a fair return for the development of our state resources. This includes especially resources owned by the American public, like our federal oil and gas resources. So we're very concerned about the policy that this bill creates by not allowing the federal government to responsibly collect revenue from the development of coal, oil, and gas resources by refunding that essentially to the companies. We believe this bill is not needed now. There hasn't been a policy initiated at the federal level to raise federal mineral royalties. So it's really a bill looking for a problem. And I would note specifically that there's already a process in place in the federal regulations that allows a company to apply for royalty relief. So if a company ends up having an issue with paying that extra federal mineral royalty, they can apply to the federal government to get that royalty amount reduced. And in fact, operators in Wyoming have taken advantage of that recently to a very large degree, particularly during COVID, but also more recently, the coal industry has been using royalty relief to reduce their federal mineral royalties. So again, there's already a process in place at the federal level that acknowledges a potential burden that operators could have in a way to, and provides a way to address that. We would also note that, of course, there's been study and evaluation by the GAO specifically, independent evaluation that has shown that an increase in federal mineral royalties will have very marginal impact on production. As we all know, and we've talked about this for years, the most important factor is the geology. Wyoming happens to have really good geology for our federal mineral resources. And the second most important factor is the price of that resource. And so those are the factors that matter the most. Taxes and royalties and other issues are below that in terms of whether operators end up producing or not. And then finally, I would note that there has been some good discussion, I think, about how an increase in the federal mineral royalty rate would impact severance and ad valorem taxes because of that valuation question. But I would note that that could be fixed separately. We don't need to refund operators to address that. And so I think that there's a piece of what Senator Boner was talking about on Friday, kind of shifting a little bit of money and making sure that we make our severance taxes and ad valorem taxes whole. If federal mineral royalties are increased, we can still do that without having the refund portion of the bill. So again, I think it's kind of a red herring argument and it shouldn't really be the focus of your discussion. I hope that makes sense. I'm happy to answer any questions you may have.
Questions for Shannon, please. Hearing none.
Okay,
Thank you, Shannon, for your testimony. Any other public testimony? Yes. Fella in the back of the room. Good move. Yeah.
Mr. Chairman, members of the committee, my name is Richard Garrett, and today I'm just speaking on behalf of myself, an individual citizen of the state of Wyoming, born and mostly raised here. Like all of us, I think in this room, I've benefited from mineral development. I think of myself sometimes as the beneficiary of a trust fund. And our mineral developers have by and large done it right in this state. And we are a leading energy producer in the country as a result. At the same time, I feel as though I have not had the opportunity to pay my fair share of the burden that is imposed on the mineral industry and others too in this state for the work that they do on our behalf. So as unlikely as it might sound, but perhaps you've heard me say this before, I would favor reduction in mineral taxes if there was another side to that, and that would be an income tax imposed on Richard Garrett. Now, I don't know how the rest of the folks in this room might view that, but I would welcome that opportunity for sure. Another concern with this bill, though, is that it might inadvertently and with an unintended consequence in some way incentivize development on otherwise undisturbed habitat and landscapes. And if the bill could be amended in a way to include only development on existing leases and a credit on those existing leases, that would be at least some measure of improvement in my mind. So I respectfully ask the committee to consider that and to go ahead and tax me. With that, I'm glad to stand for any questions.
Any questions for Mr. Garrett? Mr. Garrett, I'll work hard on getting a Richard Garrett income tax done. But that's all. That's a Richard Garrett one.
Thank you, Mr.
Any other
Chairman.
questions?
That would memorialize my life.
Yeah, it would. Yes, it would. Yeah, you'd go
Thank you.
down in history.
Thank you.
Richard Garrett, IT. Okay, thanks, Richard. Anybody else? Anybody else in the public? Yeah, Pete.
Good afternoon, Mr. Chairman,
Good
members
afternoon.
of the committee. Pete Overmueller with the Petroleum Association of Wyoming. Appreciate the opportunity. Real quickly, Mr. Chairman, just wanted to give the committee a quick update. As of today, this week, we have 14 rigs running in the state of Wyoming, which is certainly better than July of 2020, but not where we'd like to be. It's less than half where we were the month before the pandemic took over all of our lives.
Down one from last week.
Down 3 from last week, Mr. Chairman, but regardless,
Really?
who's counting? Despite that, oil production and gas production has been slowly recovering, in part because of the work of the Energy Rebound Program and all of that. We were able to recover production without necessarily the need for a quick increase in rigs, but hopefully we will see rigs coming back sooner. Most notable, Mr. Chairman, is that just last week, middle of last week, the federal government missed their deadline in order to hold their first quarter lease sale in 2022, despite having a court order requiring them to do so and having said that they were going to do it in 2020. For Q1 2022, they did not. That's 5 consecutive quarters without a lease sale in Wyoming, with an immediate estimated impact to revenue of $47 million. Meanwhile, you asked, Mr. Chairman, when you held this over, or maybe it was Senator Rothfuss asked about knowledge of a pending increase. No official action has been taken. You probably saw in the news, like the rest of us, the leaked memo from the Department of Interior expecting to raise federal royalties to 18 3/4 as part of the upcoming and yet still not happening lease sales. So, Mr. Chairman, turning my attention to the bill, in sort of true Pete Overmueller fashion, I've written a bunch of notes that would lead to a stem winder of a speech, but mostly is to push back against the narrative about things like a broken leasing system that actually isn't broken, that sort of thing. But out of respect for people in the room waiting for their bills, I'm not going to do that. I just want to make sure, because we've held this over. I think Senator Boner did a fine job of explaining the bill, but the narrative from or misleading press sources, but also in testimony like we just heard, is that the bill does not prevent the federal government from raising royalties. The bill does not provide operators with a rebate of the federal share of royalties. It doesn't provide a rebate for the current existing federal or state share royalties. All the bill does is it says if they follow their leaked memo and go to 18 and 18.75, that delta, 100% of which goes to the federal government, and then 49% comes back. We're only talking about that 49% of the 6% increase. And then after that, you multiply it by the 75% that the Department of Revenue talked about. It's only 3/4 of about 3%. It is a small token, a gesture of something in Wyoming's power to mitigate what the impact will be of a federal mineral royalty. The federal government will still get to enact its pound of flesh, much to the delight of organizations that purport to support the responsible production of oil and gas in Wyoming. It's a policy decision on the part of the state to slightly mitigate that impact in order to keep Wyoming competitive. I've said it over and over again, it's not just me. Multiple studies have shown that we are the most expensive oil and gas state when it comes to taxes and royalties, more than twice as expensive as Colorado, 3 times as expensive as New Mexico. All this bill does, and I really appreciate the work of Senator Boner and that committee, is try to mitigate that a little bit. It's a policy consideration on your part. I understand that, but I think it shouldn't be in the same category as previous bills on severance incentives, because it does not reduce our taxes. It mitigates an increase. We'll still be paying an increase. It just mitigates it slightly. And Wyoming remains status quo in terms of the revenue that you can expect, have expected, and can expect from oil and gas. Mr. Chairman, happy to take questions. Thank you for indulging me.
Question for Mr. Obermueller. Questions, yeah. Senator Rothfuss.
Thank you, Mr. Chairman. Mr. Obermueller, on the discussion, which we've had a lot about us being among the most expensive states, and you and I agree on that, but the concern I had, though, is when you say that we're twice as expensive as Colorado and 3 times as expensive as New Mexico. I struggle at where you get those numbers based on my recollection of the independent study that we had done. That's not how I would characterize it. So how are you arriving at 2x and 3x when I would say a couple of percentage points different would be how I would characterize it?
Mr. Chairman.
Go ahead.
Senator Rothfuss, I wouldn't characterize it that way. The organization that characterized it that way is the Colorado legislature's version of the Legislative Service Office. They did a study to look at Colorado's tax and royalty regime compared to other oil and gas states. And it was Colorado that determined that they were less than half in terms of tax and royalties than Wyoming. I will share with you again. I've shared it with the committee before, but I will send it to you again.
Yeah, thank you. And I'll just say that I have read that when you last shared it, and I think their math is interesting, I'll say. But I do think that, and again, if the committee wants to see this one as well, the report that we had that still indicates your conclusion, which is that we're expensive. I just don't think you could draw from that other report about the taxes anything resembling 2x or 3x when they did an all-in analysis and tried to put it on an apples to apples. And I'm sure you recall exactly which one I'm talking about, and probably even which chart I'm visualizing, and you're probably visualizing the same chart. So yeah, I think it's important, though. 2 times the taxes and 3 times the taxes, that's a big statement. So please do send us that again, if you would. I know I have it, but it's probably 20 or 30,000 emails back. And if you'd bring it to the top for me, I would appreciate that. Thank you.
Mr. Chairman, I'm happy to do so. And I would simply argue that, far be it for me to stop you from arguing with the Colorado legislature over that issue, but regardless of whether it's 2x, 3x, or just the most expensive, when federal royalties go up, we don't become less expensive in that case. And with all the talk of needing to rely less on federal minerals, anyway, thank you, Mr. Chairman. I'll stop there.
Mr. Obermueller, is one of the factors that makes us more expensive than some of our other states, the federal tax? or is it some other tax?
So, Mr.
Federal
Chairman,
royalties?
yeah, Mr. Chairman, I appreciate that. There's, of course, there's not really a monocausal explanation for anything. In the case of the federal royalty, of course, any federal acreage or federal mineral production, no matter the state, is applied, the same royalty is applied. So that's simply apples to apples. You add that, of course, you compare us to private land states, and then it's not apples to apples anymore, and we're more expensive than private land states. Then you add in our particular tax structure, which actually is more expensive than other tax structures. Then, of course, there's all the other things involved. So the study, the Colorado one and the one that that the senator referred to that you all commissioned, simply looked at taxes and then taxes and royalties in the case of Colorado. In terms of overall expense, there's more to it than that. Our very, very high cost of electricity in Wyoming is quite burdensome. There's of course other issues in Wyoming too, but it's an expensive place to do business, and that's fine. It's the cost of business. We just would hope that we wouldn't continue to rise.
But Mr. Obermueller, the cost of electricity is not part of this study about
sir.
the taxes. Is
No,
it?
sir.
Yeah, okay. All right. As we normally do, we would introduce any legislators in the room, and we're pleased to have Senator Boner with us again today, and we're pleased to have Senator Nethercott with us today. Thank you. They've come to see everything about minerals. Any other questions? Any other questions for Mr. Obermueller? Hearing none. Thank you,
Mr. Chairman.
Thank you, Mr. Obermueller. Is there anybody else in the public who'd like to speak? Oh, there he is.
Thank you, Mr. Chairman, members of the committee. I'm Travis Detai with the Wyoming Mining Association. And in the interest of time, I will be short. I think my colleague from the Petroleum Association hit most of the key points. Speaking specifically to coal, and we support the bill. We support the concept. This is just another way to mitigate some of the stuff that we see developing out of Washington, D.C. As the committee most likely knows, the Department of Interior has undertaken a study to review the federal coal leasing program. We fully expect, it would be nice to be the optimist, but we fully expect that one of the recommendations will be to raise the royalty rate on surface coal from 12.5% to around 18.5%. And we, as one of the previous speakers noted, we do have an opportunity to apply for royalty relief. It's not common. We had 4 companies apply during the COVID-19 pandemic. 1 received it. In the Build Back Better bill, that option was stripped out, along with other things that would raise the cost of producing coal in the United States. So these things are coming from Washington, D.C., and we see this bill and this concept as, again, just a way to mitigate some of those increases in the cost of production that we're going to be seeing, or we have the potential to see in the near future. So we support the bill, Mr. Chairman.
Thank you. Any questions for Mr. Detai? Questions? Yes, Senator
Yeah.
Rothfuss.
One other question. Thank you, Mr. Chairman. Mr. Detai, talking about the rates, the 12.75%, which is the current typical rate for federal leases versus the 18.75. Now, I realize there's an awful lot of production on federal land in Wyoming, but there's certainly some production on private land of coal, albeit smaller. Regrettably, most of those negotiations and those contracts are proprietary. But would you have any ability to speculate for us on what the negotiated royalty on private property would be?
Mr. Chairman, Senator Rothfuss, I could not even speculate. I wouldn't even, I could probably do some digging around and maybe follow up with you. But right now, I would not even have a clue on that.
Thank you, Mr. Chairman. And a quick follow-up question on that. It's my understanding that the federal study, both for coal, oil and gas and other minerals, was largely based on the disparity between the federal mineral royalty rate of 12.75% and what is typically seen in a private royalty agreement. I know that last year, or perhaps the year before, Mr. Chairman, I've lost track of time in this COVID era, we did some work on state royalties and tried to normalize that to something that we saw as more appropriate and approximate to what we were saying in the mineral sector, which might not be 18.75. I don't think that's where we arrived, but if you could get us more information on that, I think that would be helpful for us to understand. And then the question would be, is that your understanding also of how this process, albeit maybe 18.75 isn't the right amount, but is it your understanding as well that the 12.75 was seen as a significant discount relative to private land?
Mr. Chairman, I don't think I would agree with that. I think the driver for the review of the federal coal program, both in the previous, the Obama administration and in this one, is driven purely by politics and by the idea that you're not paying a high enough royalty. We're not getting enough value because we say we're not. And I think anybody looking at the federal coal program over the last 30 years, where we've seen money from that federal coal build schools in every county in Wyoming, where we've seen it pay up until recently almost $1 billion a year off of federal coal to state coffers. The idea that we're not getting value from the program is borderline ridiculous. And so I think it's a political thing, and it's the folks that pull the levers of power in Washington, D.C. Have made it quite clear that their goal, the ultimate goal of all this, is to keep the resources in the ground. And you do that by driving up the cost of production so that it's non-economical to produce. So I think it's a political thing. And back to the bill, this is something that the state can do to help mitigate some of those efforts, should they be successful in Washington, D.C.
Mr. Chairman, and rest assured, that was, from working with you for a lot of years, that I truly appreciate the federal mineral royalties. And I was there on the select committee on school facilities, spending well over $1 billion of those dollars appreciatively. But at the same time, I guess the question then is, since we don't know what the private rates and royalties would be, and we can only speculate what the motivation of the feds would be, we could potentially ask, is it fair if the state of Wyoming receives a similar royalty to what a private royalty rate would be, or should we be subsidizing?
Mr. Chairman, I'm not sure subsidizing, I don't quite understand that, but I think that if I can find the information you're looking for on private rates, which are negotiated in confidence, to get sort of a benchmark. Is that what you're looking for, Senator? To maybe make the comparison? I'm happy to try to find that out.
Absolutely. And I realize it will vary, and I realize that, again, it's private contracts, but it is my understanding, and this may not surprise you, but disagree to some degree on what the effects would actually be. It is my understanding that, particularly with a domestic market, if you uniformly raise taxation, then you do provide opportunity for different commodities potentially that would be taxed lower to get in the market. But if you're uniformly rising taxes across all of the sectors, it tends to actually wash out, and you don't end up discriminating the marketplace. So we might disagree a little bit on this being a method for driving a sector out of business. The motivation that I hear tends to be trying to get that 18.75 to equal what the private negotiation would be. And I would certainly feel a lot better if I learned that in the state of Wyoming, everything was 16%, for example. And if that were the case, I would see some justification here. Thank you.
Mr. Chairman, I can try to get you some information on that, and we can continue the discussion. Senator.
See what you can find. Yeah. Do you think if we raise those rates, the feds raise those royalty rates, it can move some coal mining onto private land? Yeah.
Mr. Chairman, I would say no, just because the bulk of the coal is where it is.
There's another shelf on the western side of that. It's all private over there. Over there along
Mr. Chairman, that would take a lot of investment to move over there. So I would my answer to the question would be probably not.
Probably not. Okay. All right. Thank you.
Thank you, Mr. Chairman, members of the committee.
Any other public comment? It appeared that Senator Boner was anxious to comment? I guess not. He's just looking that way. Anybody else? Anybody else? Anybody else? Nope. If not, there's nobody on the Zoom. Nobody on the Zoom, nobody in the room. We'll close public comment. Committee, what's your pleasure? Move by Cooper. Second by okay. We want to work through this, or do we want to just do an amendment or two that we have already figured out? What's your pleasure? Do every page one thing. We have one. We have one. Let's work this one of standard bonus. On page 2, line 9, line 9. After amount, it's insert specified in this subsection, the amount of the transfer shall be. Then on page 2, line 11, it's after the code 209C 4. Then he wants to insert that amount shall then be multiplied by 16 and 67/100%, 16.67, the product of which shall be included with the funds transferred under this subsection and separately distributed in accordance with WS 39-14-801B through E. And then on page 6, he wants to amend line 7 after 94601N, insert to provide the severance tax refunds authorized by WS 39-14-109C4 and 39-14-209C4. Is there a motion on that amendment? Is there a motion on that amendment? Oh, moved by Cooper. Is there a second on that amendment? And there is a second by Bateman. All right. Any discussion? Any discussion? Well, he did, guess, last time we met, but he can have him do it again. If that's what Senator Wasserberger wants, that's what we'll do. Yes.
All right, so just as a reminder, committee, we have that basically 25% reduction of the state share of the proportional increase. That's meant to compensate for the decrease in severance tax and ad valorem taxes. So just an additional wrinkle that, when we get down to how our revenue streams flow, this amendment would take half that, so about 12.5%. If you look at it in terms of the overall state share of the increase and move that from FMRs to the severance tax to account for the decrease in severance taxes. So it's a policy choice for us. I would say that hopefully this is the, this is additional opportunity to make sure that we keep that revenue stream whole, in addition to providing the tax refund to the affected industry. So that's what it is. Policy choice for us. I think it's an important one, but certainly shouldn't detract from the bill one way or the other.
Questions? Senator Rothfuss.
Thank you, Mr. Chairman. First of all, I appreciate the spreadsheet and being able to play around with this a little bit, as well as from the department, wherever the department is out there. There you go. To play around with these numbers a little bit. So it's my understanding, Senator Boner, that the attempt here is to try to make sure that the same values and same percentages that are in the budget flow right now are reflected if this were to pass afterwards, with regard to the percentage that our FMRs will say and the percentage that are severance. So the intent of this amendment is to hold things as neutral as possible relative to the status quo. Is that accurate?
For severance tax, yes, Mr. Chairman.
For severance tax and FMRs as well, right? I mean,
Right,
you're
and they're-
balancing it out. Okay.
Right, and half the FMRs, remaining FMRs. yeah.
Correct. Okay, thank you.
Other questions for Senator Boner? Other questions? Nope. Thanks, Senator Boner. Thank you once again. Good, moving and seconded that we adopt Senator Boner's amendment. All in favor, signify by saying aye.
Aye.
All opposed, same sign. That one squeaked by. Back to the bill. Any more discussion on the bill?
Mr. Chairman.
Yes.
Thank you, Mr. Chairman. I can't support the bill, not because I'm not sympathetic to the concepts. And I think to reiterate what Mr. Garrett said in his testimony earlier, if we had the capacity to create a more balanced and appropriate revenue structure in this debate, in this state, if we had the political will to balance things out, I would be on board with that. And I think we overtax the mineral sector relative to every other sector of the state rather significantly. We don't have that political will. And until we get to the point where we actually have the capacity to have a real conversation about it and rebalance, when we see an opportunity to actually increase revenue in the state without doing damage to industry in the state, and I do not believe this does damage to the industry because it's across the board throughout the country. If this were unique to the state of Wyoming, this would be a bad thing. This would hurt industry, no question about it, increasing the royalty rate. When you uniformly apply increase in taxation of this level, and honestly probably make it something more similar to what is on the open market, it is not going to injure unless there's enough of an international component that the commodity could be going elsewhere. And I don't see that here either. So I do not see this negatively or adversely affecting industry in the state. Although once again, I would love to simply sit down and contemplate a tax structure that allows me and the financial sector and some retail sectors and other sectors to pay their fair share so that we can bring down the total costs that we're forcing and continuing to force upon the mineral sector. Absent that political will, I can't support legislation like this.
That does not sound like a Richard Garrett income tax move.
How
One of
much,
the-
how much has he got in his pocket?
I don't know. Let's take it from him.
We just do the one tax on the one guy.
Yeah. So one of the problems with that thinking is the problem that Wyoming has is we're 50% federally owned. So this royalty affects us more than it does another state like maybe Texas that is very, very little affected by this. Even our friends in Kansas and maybe Colorado also don't have as high a percentage of federal lands. I think New Mexico does, but the reason this affects us so badly is because of how much we rely on federal land to produce our products. So that is a counter to that.
Yeah, Mr. Chairman, quick response to it. And
Sure.
I understand that point. I do think that if we actually had any of this in practice and this were a past tense conversation where we could look at data and see, were you right or was I right on this? That would be a helpful time for us to be passing legislation, but to prospectively decide what the implications are going to be before we even know what the rate will be. And honestly, we still haven't seen any hard data on what this would cost. My back of the envelope or back of the spreadsheet was $150 million. That was what I came up with. And again, what am I right? Maybe. I took the spreadsheet and used current rates and current production rates on oil. That was how I got to about $150 million. That's pretty substantial. That would help us to solve a lot of our problems. And again, if I don't believe it's going to hurt industry in the state, and reasonable people can disagree on this, I don't have certainty. But wouldn't it be interesting if we actually had the data to retrospectively decide whether this was a problem instead of prospectively giving what could amount to, in current conditions, $150 million of a tax credit to an industry that is not currently struggling, but we know they will again.
Question.
Okay, question on the bill. I'm going to have a roll call on this one. Roll call, please.
Thank you, Mr. Chairman. Senate File 84, Senator Beitman,
Aye.
Senator Cooper,
Aye.
Senator Rothfuss,
No.
Senator Wasserberger,
Aye.
and Chairman Anderson.
Aye.
That's 4 ayes, 1 no. Do pass amended.
All right, thank you. That bill, Senate File 84, has passed. the Senate Minerals Committee, we'll move right on to
Let's do that next. out of order.
one of the committee members wants to move a bill. He wants to move Senate File 68 up next instead of being in the sandbox. He wants to,
It'll
do
be a little
something else.
shorter and then Sandbox next. My apologies, but
pardon me? Okay, we're going to move, the chairman's going to move Senate File 68 up and you do it before Senate File 55. Okay, Senate File 68. Do we
Mr.
have a presenter on? Yes.
Yes, Mr. Chairman, who is going to present on the floor? Number 84.
Well, it sure isn't
Oh,
going to
that
be
was-
Rothfuss.
that would be Senator Boner.
That's gonna be
as- yeah, from
Senator
his committee.
Boner.
Yeah.
We'll skip Boner. We'll skip
In a pinch,
Rothfuss on
in
that
a
one.
pinch, I'm happy to. Mr. Chairman, in looking at the workflow, Senate File 68, I think will take less time. Senate File 55 takes a little bit of walking through. So in the interest of trying to get through a couple of bills
Okay,
today.
let's do
potentially.
Senate File 68.
All right.
Who's going to present
I'll
that? Are you?
start presenting, but I'll ask Mr. Kaufman, who is a member of the Blockchain Select Committee, to come up and join us and help me as I work through it. Mr. Kaufman has been a member of the Blockchain Select
I
Committee.
think Senator Nethercott wanted to do that.
Yeah,
You
Senator
didn't call
Nethercott,
on
I
her.
would love to have you if you
You
want me.
didn't call
if
on
you
her,
want
so
to. Okay.
no, she's
Got it.
out.
Thank you. Mr. Kaufman has been a member of the Blockchain Select Committee and has been working on the DAO legislation, both the first draft and this one as well. And we've had a working group through the interim that I want to say has met maybe 7, 8, 9 times, quite a few, which includes experts from all over the country and all over the world that took the time to review our legislation that we passed and became effective on July 1st. Again, to remind the committee, this is the first decentralized autonomous organization legislation in the country, and to some degree, probably the world. So it's pioneering, but we got a lot of feedback, good feedback, and there are probably 3 issues in this bill that we're just trying to correct, as well as some cleanup as well. With that, I'd ask Mr. Kaufman to walk us through those issues, and hopefully we can kind of expedite this one and
Okay,
get through with something today.
Mr. Kaufman, go ahead.
Thank you, Mr. Chairman. My name is Matt Kaufman. I'm a partner with the law firm of Hathaway and Coons here in China and a member of the Select Committee along with Senator Rothfuss. Mr. Chairman, just a quick overview of the bill to refresh everyone's memory. As Senator Rothfuss was just saying, last year, the legislature passed a first of its kind entity in the world here in Wyoming called the DAO, the Decentralized Autonomous LLC. This is organized and designed to be a subtype of our LLCs here in Wyoming. Specifically, without going into too much detail, we have 2 predominant types of LLCs in Wyoming. We have manager managed LLCs and member managed. DAOs are designed to be a default member managed LLC. As such, a lot of the rules and cleanups that we present here today are simply those that, quite frankly, we didn't catch on the first draft through. And now that we've had a year to understand how this bill's working and how companies are using it and enacting it, we found some cleanups, quite frankly. So the vast majority of the changes in this bill are designed to address those cleanups. Mr. Chairman, starting on page 2 of the bill, the first cleanup is just a simple amendment to the majority of the members definition. Again, cleanup language to make it clear how a participating member is defined under the act and what those participation rights are. At the bottom of page 2, Mr. Chairman, again, the membership interest, which think of membership interest as language that you would use instead of saying stock in a corporation, you have a membership interest in an LLC. Again, we're cleaning up that language so that it's consistent with the right in the entity and bringing those definitions into conformance. Moving down on page 3 in the definition of smart contracts. Again, just a refresher for everyone. Smart contract is one of those definitions that's a fundamental linchpin of the DAO Act. And a smart contract is simply an algorithmic agreement, something that is automated in code. And so we took a little care and time to clean up the definition of the smart contract terminology in this. Again, consistent with how we were hearing testimony that people are using these agreements and how the agreements are being carried out. Moving on to page 4, Mr. Chairman, in 1731-104, This, in my mind, might be one of the biggest changes in this. We understood after we passed the act that we inadvertently created the assumption from people that there were two types of DAO LLCs. Again, it was one of the reasons I set forth that explanation that we already have two types of LLCs in Wyoming, the member managed and manager managed. These are designed to be member managed LLCs. The articles have to disclaim how much algorithmic control these LLCs are relying on. So this cleanup was simply that, to make that more clear. At the top of page 5, we have some brand new language that was a request of the Secretary of State's office. One of the features of the decentralized autonomous organization filing is it's required to disclose that smart contract protocol or the algorithm that it relies on in terms of operation. What the Secretary of State found is that some actors are filing these entities without those public identifiers, hoping that they'll come back and figure it out later. The Secretary of State's office asked and said, you know what, if somebody files and they don't provide that public identifier in 30 days, we want to just deem them not formed and reject that filing. I think the consensus of the committee, that was a good policy decision. Moving down to the bottom of page 5, again, we're just simply adding some functionality here to the articles of organization, providing for modification for dispute resolution and a few other cleanups. Moving on to page 6, Mr. Chairman, and feel free to slow me down if I'm cruising through this too fast.
I thought you were too slow.
Okay, fair enough. That's true. 1731-108, again, just clarifying language to bring the operating agreement language in conformance with that of the articles. Same with 1731-109 with respect to management. Again, referring back to that change I mentioned, that was one of the biggest changes in my mind. We're not trying to have two different types of subset of DAOs, and some of the language created a confusing comparison between the two. So simply cleaning that up. Mr. Chairman, on page 7, again, just simple language cleanups. We're striking language and adding a few clarifying phrases there. And then finishing up on page 8, Mr. Chairman, we have 1731-113. This is with respect to the withdrawal of members from an LLC and creating how they can do that. Again, statutes designed to be default rules. Parties can by contract or agreement do essentially whatever they want. But we just clarified what the default rules were for a member withdrawing from one of these entities and what those different ways that the members can withdraw are. And then lastly, Mr. Chairman, and again, this is probably, I would put in the bucket of one of the other large changes to the bill, and it starts on page 9 and then carries on to page 10. This is with respect to ways that these entities can be dissolved at law. The original act had language that interested parties could petition the Secretary of State's office to ask them to dissolve an entity. That's not how we do things with any other entity. With corporations and LLCs, if a member or a partner wants to dissolve an entity, they apply that petition with the district court or a court of competent jurisdiction. So we changed that language to make it the same here. With that, Mr. Chairman, Senator Rothfuss, I think I covered everything. Feel free to add anything I missed. But again, Mr. Chairman, I would add that the committee worked through these changes extensively with the not only the task force, but the public participants. I would say these changes, quite frankly, we tried to get some of them in last year before we got the bill through and we just ran out of time. So a lot of them have been worked on for quite some time.
Mr. Chairman, tacking on a couple of things. One is we'll probably have another bill a year from now, which hopefully will be minor revisions, but we had a few more things we were discussing that again, weren't necessarily quite ready and agreed upon. So this is an iterative process since it's the first of its kind, but all of these are uniformly improvements that were agreed upon by all of the members of the working group. And so we appreciate all of their efforts. And the other thing I'll say is I think we're over 200 registered DAOs, if I'm not mistaken, since July 1st, or at least in that ballpark, based on testimony from the Secretary of State's office last time we heard from them. So there's a lot of interest in this space.
Any questions for Matt? Any questions? I have a question. I wrote down that it's a member managed LLC, but I'm going through it and it seems like it's not. It's some other definition here. decentralized autonomous organization. Is that a member managed organization, LLC?
Yes. So, Mr. Chairman, this is a subtype of our Wyoming member managed LLC.
Oh, okay.
What the decentralized autonomous aspect allows the LLC to do is to delegate decision-making, functionality, contracts to an algorithm, essentially, to a smart contract, to a non-human actor, which is first of its kind anywhere in the world. So essentially what you can do, Mr. Chairman, I wish I could bring for you all a demonstration of how some of these entities are working. As a corporate lawyer, I could tell you it's the way that I think we envision entities should work sometimes, because what you can do, let's say the four of you were all members in an LLC, the LLC received a distribution of some digital asset. You could have an algorithm set that as soon as that distribution hits, right, your company, there's an automatic distribution based on some formula that is set and automatically occurs. And it's just programmed into the entity, and it can be included into the articles. It can be included into the operating agreement, and then the actors can rely on that and incorporate that into their corporate governance. So that's what people are doing now with digital assets and even non-digital assets as well. But it's a new way to allow members or participants in an entity to contract with each other.
On page 7, line 8, you lined out member managed. Wouldn't that still fit? It's a member managed, decentralized autonomous organization.
Mr. Chairman, it is a member managed autonomous organization by definition, but the members themselves can choose to delegate through smart contract certain functionality to whatever they choose.
Okay, all right. Yes.
One other thing that I'll say briefly is that this bill doesn't really do anything new. It just takes all of the feedback that we've received since passing the Dow legislation last session and tries to implement all of the best practices that we heard and resolve confusion, clarify and maybe change some actors. There's a little bit of newness, as mentioned, for example, on page 10, where we tried to clarify a little bit about a court of competent jurisdiction as opposed to the Secretary of State being the entity that you would work with. We also had some concerns of more clarification for what we call a human in control, where some human has to be behind this at some level and capable of refining or amending it. So we added some clarity there. But again, everything in this bill really is consistent with the original legislation. Although when we took feedback, we heard a lot of confusion and a lot of ambiguity. So we took the opportunity to address it through this bill.
Okay, all right. Thank you, Matt.
Thank you, Mr. Chairman.
Any other public comment? The agency would like to speak on this, or anyone else? Is there anyone on the Zoom that would like to speak? No? Here comes somebody who wants to speak. Oh, no, he wants to sit. Okay. All right, we'll close public comment then. Committee, what's your pleasure?
Move the bill.
Moved by Rothfuss, seconded by Wasserberger. Any discussion? Any discussion? Any discussion? Any changes? Any additions? Any amendments? Hearing none, sensing the body's ready to vote, would you do a roll call for us, please?
Thank you, Mr. Chairman. Senate File 68, Senator Beitman,
Excused.
Senator Cooper.
Aye.
Senator Rothfuss.
Aye.
Senator Wasserberger
Aye.
and Chairman Anderson.
Aye. That bill squeaks by and Rothfuss is going to present it.
Now I'm going to have Senator Nethercott do it since she left.
Yeah, she left, so.
Senator Nethercott's a
she's-
long-standing member of the select committee as well. So
All right, the next one to come before us is Senate File 55, Insurance Sandbox. Insurance Sandbox.
Mr.
That
Chairman,
that fits in with minerals. We're in the sandbox.
we're a Sandbox.
Yeah,
And
we're a
Mr.
sandbox kind of guy.
Chairman, I'll present this, and then I know that we have the insurance department that can provide some comments on this as well. And may have others that want to provide testimony, but Mr. Chairman, this stems from conversations a couple of years ago related to the select committee with regard to interest in the state of Wyoming in reinsurance specifically. So reinsurance, that's the insurance providers that insure insurance companies effectively, and they are not public and consumer facing. They're dealing in large transactions, typically with insurance providers. And so it's a very different business model. And there was interest in exploring Wyoming's engagement in the reinsurance market and our statutes, how we might be able to amend them in a way that would make them more workable for reinsurance. So the first thing we thought through was this approach to an insurance sandbox. And we actually later ended up developing some specific legislation, which if it makes it out of the House, we'll see later. But the insurance sandbox is similar in structure to the financial technology sandbox that we ran, I want to say 3 years ago, out of the blockchain select committee, our blockchain task force at the time. And the idea is to create a structure wherein our agency or department that oversees this specific sector of industry and regulates it has the authority statutorily to bend some rules and regulations or bend some laws on a temporary basis with strict oversight and scrutiny, and typically with some sort of sureties in place that they agree upon between this business entity and the regulatory entity to allow innovation without actually having to come in and change the law. And we did this with financial technology. So we did it specifically with business and with banking. There was a lot of enthusiasm in the banking sector, and that led also to some of the work and things that we did in the special purpose depository institutions, which have been very successful. But what honestly happened for the most part with the fintech sandbox wasn't that anybody came in and used it. What they came in and did was that advertisement, sort of the availability of the fact that we would work with these industries, attracted industry that then came in and typically would work with the division of banking and find out that they didn't need the sandbox in the first place, that they could work with an existing law and get to where they wanted to get. So it's been successful from the standpoint of showing that we're open for business and that we're flexible and that we want innovation. But at the same time, on the old legislation, it really hasn't been engaged. There were about 3 other states that had these fintech sandboxes, and we took the best of those, built what is probably still considered to be the best sandbox. And I think a couple of other states since then have copied it. With the insurance sandbox, it was a similar discussion. What if we did with the insurance industry what we did with financial technologies and the business sector through the Secretary of State's office by giving our Department of Insurance the ability to provide flexibility with oversight and again, working with these entities. Now, to be clear, there's no shall in this. This is very much a may. It gives the insurance commissioner the ability to contemplate, is this a good idea? And we'll see that as we get through it, or is this too risky? And most importantly, with some exclamation points in here a couple of times, if anything were to potentially threaten our NAICS accreditation, then the insurance commissioners specifically required not to do that, right? Do not threaten our accreditation first and foremost. That was what they emphasized over and over again. And so we strengthened the language and got to the point where I think we've got some good authority here for that. So I'm going to briefly walk through the legislation, but it parallels the previous legislation that we had with the financial technology sandbox. So you see on page 2, this is language that's similar, but with the insurance sandbox language as opposed to the business or fintech sandbox. One thing that I'll point out is that it's a 24-month initial period, as you see on page 3, line 18, and not longer than that without permission through an extension by the commissioner based on some success. The reason for that 24-month period is what we heard in testimony previously with the fintech sandbox is it probably takes 6 months before you're doing anything at all once you start one of these projects and get into a sandbox. And then we wanted some period of time for it to operate, as well as a couple of legislative sessions, so that if we needed to correct something, we could do that. So the extension would allow one more year, which gets you to 36 months. The idea being we would definitely have a legislative session where we could correct and provide any legislative tweaks that might be necessary to enable this to continue if the legislature deemed it a good idea. So gives us the opportunity to give the flexibility, but not for an indefinite period of time, for a time certain. On to page 4, this is the authority for the commissioner with regard to the insurance sandbox. And you can see it almost seems unnecessarily awkward the way the rest of the next few pages is laid out. But it's the same way we did it with the previous sandbox. It lays out all of the statutes in order that can be exempted by the insurance commissioner. And you see it takes a couple of pages to lay those out. And those are basically all of the provisions that apply to insurance and that are within the authority of the insurance commissioner. Now, candidly, and you'll see that we've got some provisions a little bit later, there are many of these statutes that there's no way any of us would come up with a reason why you would want to bend or break them, because they would almost certainly threaten the NAICS. And we had the same discussion when we were talking about the fintech sandbox, for example, securities under that. There was never a circumstance where we expected to be able to bend the laws in Wyoming statute that said you shall enforce the SEC's security requirements. But we left them on the books knowing they probably would never be used, with the idea that if we have a clear directive that says don't do anything that would threaten NAICS certification, they wouldn't engage with those unless somebody did come up with an idea that was allowed. And the idea that we could foresee every business practice in the future seemed unreasonable, so we provided that flexibility. But it's called out in a way that if anybody was particularly troubled by any of these Romanettes, it would just be an amendable strike through. That's the way the committee left it through the Blockchain Select Committee. On page 9, it talks about an extension of the fact that any innovative insurance product or service available to consumers to this chapter is not immune from civil damages for any acts or omissions and is subject to all criminal or consumer protection laws. There's nothing that waives away any obligations on fraud or consumer protection. And in fact, you'll see that there's a lot of additional requirements for consumer protection throughout this. C and D are similar provisions that are just emphasizing the requirements to provide that protection. And then page 10, the E paragraph is important, which is no waiver or element of a waiver shall be granted under this chapter if the waiver or element would jeopardize the state's NAIC accreditation or would violate any requirement associated with NAIC accreditation. So that's essential. And that was the biggest concern, is to not violate that. But I wanted to call out one further provision that strengthened it. If I can find it, bottom of page 13. Yeah, but just briefly skipping ahead to bottom of page 13 and onto page 14, that amplifies this a little bit. If an application seeks a waiver of a statute or rule relating to these specific statutes that are laid out, which is a subset of the previous list, the commissioner shall coordinate the terms of the waiver with the NAIC prior to approving the waiver to ensure there is no violation of it. In other words, those are the ones that were identified by the insurance commissioner as the most significant and of concern when it came to NAIC accreditation. So the requirement here is if any of those are touched in any way, they are to coordinate directly with NAIC before approving anything to ensure that they won't be putting anything at risk, which is, again, the biggest concern with this legislation is nobody wants to do anything that would endanger our NAIC accreditation. So going back to page 10, this is details of the Sandbox application process, as well as the consumer protection bond, which is required, and that may be negotiated between the insurance commissioner and the entity based on an assessment by the insurance commissioner of what an appropriate bond would be for protection. There's an application fee at the bottom of page 11. On page 12, some requirements for the process of trying to respond within 90 days. More details of the process itself, the nature of the innovative insurance product or service proposed, and then additional details related to that application that you can see on page 13, the Romanettes, which includes risks, a specific business plan, appropriate personnel, adequate financial protection, any other involvements and disclosures that are deemed necessary by the insurance commissioner. And then you can see on page 14, a catch-all on a case-by-case basis of any other factor that the commissioner determines to be relevant. 14 talks about the initial sandbox period and then the possibility of feedback and extension. Page 14, the H paragraph talks about the bond. The bond amount shall be determined by the commissioner. This is on to 15, in an amount not less than $10,000, but shall be commensurate with the risk profile of the innovative insurance product or service. That's essential. And then you can see on 15J, authorization above in the insurance sandbox shall not be construed to create a property right. So there's nothing that's conveyed beyond involvement in the sandbox. Page 15 on to 16 is the creation of an insurance sandbox account. We did the same thing for the FinTech sandbox, where we basically just allow any revenue that comes in off the sandbox to then be used by the insurance commissioner to administer the sandbox. You can see on page 16 at the bottom, operation of the insurance sandbox falls to the commissioner and possibility of an extension. On page 17, the C paragraph talks about that a consumer, or before a consumer purchases or enters into an agreement to receive an innovative insurance product, this is all consumer protection language, or service through the sandbox, the person making the product or service available shall provide a written statement of the following. And then it goes on with quite a bit of details in these Romanettes that goes clear onto page 18 of all of the requirements that provides the consumer with information to ensure that they have been duly, thoroughly, and completely warned that this is a demo product basically in a sandbox and that there may be increased risk since it has not been fully vetted previously. And again, those warnings are essential and are key to this process. 18 on to 19. Maintaining comprehensive records. E, those records may be reviewed by the commissioner. On to 19. Unless granted an extension, then not less than 30 days before the conclusion of the sandbox period, a person who makes an innovative insurance product or service available shall provide written notification to consumers regarding the conclusion of the sandbox period, et cetera. So this is the wind down routine that you see in that paragraph in the subsets. On to 20, this is a provision that we took from the FinTech sandbox, which the commissioner may enter into agreements with other states, federal, or foreign regulatory agencies if they have a sandbox that would allow collaboration. On to page 21, there's the possibility of revocation or suspension of insurance if you're messing things up within this or cause any harm to consumers. Page 23 is the extension of the sandbox period and the process for engaging in that manner. On page 24, this provides the methods with the commissioner may enforce and adopt rules pursuant to this act, as well as access to the Administrative Procedures Act for any relevant concerns. On page 25 in section 2 is an appropriation of $500,000 from the special revenue funds generated pursuant to elsewhere in the statute that would allow for administration of these applications. And again, that's not something that will probably happen anytime soon. And this is something that we can ask specifically the mechanism for when we hear from the insurance commissioner. But they have special revenue funds. They're a self-funded agency. This is within their self-funding. So it is not a new general fund appropriation. It would just be basically saying, hey, if we're going to need to do one of these things, we're going to need to put some people and resources for it. So this is a speculative budget based on the idea that they might need to use some money to facilitate a project if one comes along, but we don't know whether one will come along right away. And then the going into effect on page 26. The last thing I'll say is that this was written and created for this reinsurance, a series of reinsurance projects and concepts that we had in mind. I think those have probably already had enough attention through some other legislation that will be able to enable them without this in place, but there might be some challenges in the development of the reinsurance sector where this does come in handy and where we do have too many limitations in statute. And that's a multi-billion dollar industry that we would like to cultivate in Wyoming through the blockchain and it's the Financial Technology Task Force, and try to be a place that becomes an important player in reinsurance, and having a tool like this in place would give us the flexibility to potentially do that. So I'll stop there. I know it's a long bill and a long explanation. I appreciate your patience, Mr. Chairman. I'd be happy to answer any questions, but we do definitely have public comment that we can hear.
Any questions for Senator Rothfuss? Any questions? Any questions? I have some questions, but I'm going to hold them till I hear, maybe they'll get answered. Do the agency prepared to discuss this?
Mr. Chairman, committee members, my name is Jeff Root. I'm the insurance commissioner. With me is Ms. Johnson, the deputy commissioner. The Committee on Blockchain approached us concerning this bill in the past interim, and they were looking to put a sandbox bill together, and they modeled it from other states. We're neutral on the bill, and I would just point out that there hasn't been a lot of movement in the other states that have insurance sandboxes. But I have talked with the other commissioners in the other states. We meet regularly throughout the year. This is always one of the topics that I ask them about. And what they have said, they've seen applications. Generally, they're not innovative per se, where you have to waive a regulation. Some of them are just looking to avoid a regulation. But in any event, they are analyzed, and then they're talked with. You talk with the individual, and if they want to modify their proposal, so be it. But to date, though, I've not been aware of any that actually have been approved for as an innovation. During this interim period, we raised a number of concerns with the committee. One was regarding consumer protections, and Senator Rothfuss addressed those. And then I was fairly adamant about ensuring that our national accreditation standards were in place. The NAIC is an organization made up of all the insurance commissioners, and we set standards. And if you meet those standards, then you are accredited. And where that is important is if we have a domestic, for example, that does business in the state of Montana or Colorado, and we do, those states are able to rely upon our examinations of these entities, and they don't otherwise, if they couldn't do that, they would actually have to go in and examine them also. And that's very arduous and difficult. So it's very important that we maintain this. We were able to put a number of guardrails into place. And so I think with the guardrails we have in place, the whole point is I will never, ever, ever waive an accreditation standard. Whoever succeeds me in this job, they would have to actually, if they did not know about these standards, that they're supposed to consult with the NAIC to see if that in fact would be a problem with their accreditation. So that was, we appreciated that going in there. So while I'm a little unsure as to whether we'll see an application that ultimately will have innovation and will ultimately be approved, I believe we'll probably see a few that will have something that needs to be analyzed and looked at. And that's why we asked for an appropriation. We have no idea where this innovation what it would entail, but I do know that my offices probably wouldn't have the expertise or the manning to look at it. And so we've put out some, requests for proposals out there from agencies that do this, and they've submitted some things to us. So when in fact, if this goes through and we have that appropriation, if we get an application, we'll have the expertise on hand to analyze them and see what we can do with them. So with that, we're happy to answer questions. I'll just point out one thing, that if we never use that $500,000, at some point, we're just going to have less of an assessment the following year. That's all we'll do. So it'll never affect the general fund. And what we do is our budget is made up of taking taking our total budget, dividing by the number of insurers that are licensed in the state of Wyoming, it's approximately $2,100. If there's a $500,000 rebate, if you will, they get an extra $100 less of an assessment the next fiscal year. With that, I'm happy to answer any questions.
Any questions for the commissioner? Any questions? I have a question. Would you have that kind of money in your insurance regulatory fund? Or do you have to, the $250 a year? Would you have that much in there, or would that have to be?
Mr. Chairman, we normally, from our assessments, we keep a set amount of money in a 900 series funds just in the event that a company has financial difficulties and we need to hire a liquidator or something along those lines. This money would just sit there until we needed it. And if we didn't need it, we wouldn't use it. So.
Okay. All right. Other questions? Other questions? Hearing none. Thank you, Ms. Johnson, for your testimony. Anyone else like to speak about Senate File 55, Insurance Sandbox? Ah, another Sandbox person.
Good afternoon, Mr. Chairman, members of the committee. My name is Catherine Wilkinson, here today on behalf of American Property and Casualty Insurance Association, standing in opposition to the bill unless it is amended. We are generally supportive of Sandbox bills. However, we do think this one is drafted too broadly. It would allow basically the waiver of the entire insurance code. And while that is a may, it's still a possibility. We do appreciate the commissioner discretion. Very comfortable with the current seated commissioner that none of those would be waived. But again, it is commissioner discretion and those seats come and go. We do see it as a consumer protection issue and not a level playing field for those legacy insurance companies who go through several of those steps in the insurance code to ensure financial solvency and consumer protection to be sure that it's okay for the public to participate in that product. So we also appreciate the amendments to the bill, though, that do address the NAIC consultation as well as the non-allowance of a waiver. But we would question why those would still be in the bill if they're not allowed to be waived. So there is an amendment that is before you that hopefully you have, that we would recommend that anything that would address financial solvency of companies be taken out of the bill and not up for consideration to be waived. So that amendment would be on page 4 and 5. Page 4, delete lines 21 through 23. Page 5, delete lines 4 through 8. What those sections are the authorization of insurers and general requirements, fees and taxes, assets and liabilities, investments, and administration of assets and deposits. So again, we would ask for your favorable consideration of those amendments, without which we are in opposition to the bill, and I would stand for any questions.
But with this amendment, you're okay with it?
Mr. Chairman, that would move us to a more neutral position on the bill, correct?
Okay. Any questions for Ms. Wilkinson? Yes.
Thank you, Mr. Chairman. And Ms. Wilkinson, thank you so much for all of your participation during the interim as well. And we have discussed this a number of times, and I appreciate your viewpoint. With the suggested deletions, I think all of those deletions are on the critical priority list on page 13. Is that accurate, or is there anything missing there?
Mr. Chairman, that list actually contains more of the deletions than I am recommending in the proposal. Those were the ones that I have suggested in the amendment that my clients felt it was most prudent to be sure were not waived.
So to clarify, the list that begins on page 13 includes all of the ones that you've suggested, but then goes a few steps further and has a few other things, but nothing is missing. I just want to make sure nothing is missing of your critical concerns. I think that's true.
Mr. Chairman, I believe 2 is not in the list on page 13, and that would be the fees and taxes.
Number 2 is 264105. 105. It's Roman at 2. A2. Okay. I think unless I'm somehow missing that.
24, all mine say 26. You got a 24 somewhere?
Here,
That's
inserting
26
that.
though.
Right, no, that's what, Mr. Chairman, that's what she's talking about, these 26 right here. This Romanet 2, 26-4-105, the fees and taxes aspect of it. Okay. And what with the fees and taxes, why would a change to the fees and taxes necessarily threaten the NAICS if somebody, for example, wanted to use a different or an alternative approach to it that generated the same amount of money, but perhaps did it through a different revenue model? Mr. Chairman.
Mr. Chairman, through you, I don't believe that the fees and taxes would impact that. Checking over my shoulder, the insurance, that would just be something that the insurance, legacy insurance companies would ask to not be waived as a leveling of the playing field for these new companies that are coming in. That is something, you know, that we feel should not be taken off the book. So that I don't, that's probably why it's not in that section, because it does not impact accreditation.
Well, on that point, again, getting back to the idea of an alternative process for fees and taxes, I understand that you don't want anyone to get away scot-free without fees. That makes perfect sense. That would be, I don't think they would do that. I hope they wouldn't do that. But I do see where it would be a perfectly reasonable business practice to adjust the way the fees were paid outside of statute. And, you know, maybe it's a transactional fee or something like that, that ends up being better for the business model, cash flow. I'm just being arbitrary, but generates the same amount of money. This is where my concern is with leaving things out. And I do understand that legacy insurance interests really, and you know, my apologies to legacy insurance, but innovation is not the motivating factor for the business model of legacy insurance. It's not. It works great, right? The current system works great. And so it as long as money's being made, shareholders are happy, and people are getting paid out their through the insurance, I think there's going to be a general sense of happiness. And so the traditional sector would protect that. But there's an example of precisely the kind of thing that might not be the best solution. It might not be best for the consumers, but it's what you're doing now. And I'm worried that we've got a list maybe here where some of the things are just protecting the status quo as opposed to protecting the consumers and fostering innovation. Is there anything else on this list that you can think of that really isn't about NAIC accreditation, but is more about just protecting the status quo?
Mr. Chairman, I believe the rest of them, apart from the two, the fees and taxes, it is status quo, but those are necessary steps. And like I said, we are not opposed to the innovation side of it. I know there's been a lot of emergence of insurtech companies with ideas that have come forward. I've heard of, you know, a few that are going forward, but I've heard the activity has also died down. As stated before, you know, I don't know how much of the innovation would rise to the level of this, but a lot of it is about protecting status quo and that which has been proven to work.
Well, getting to that point, though, again, the original motivation, Mr. Chairman, if I may,
Yes.
was reinsurance, where we have an insurance structure that's largely based on a face-to-face consumer engagement. That's totally unnecessary for reinsurance, but the statutes that are the insurance statutes assume that the transaction is going to be between me and insurance company and a bunch of consumers that walk in my front door. So we have effectively some legacy statutes and a legacy approach, which is, oh, well, you'll be a traditional insurance company, and so you'll have a front door and you'll have a place to show up. The reinsurer simply needs to talk to the insurance company and engage in a very different way. So their liquidity and their investments matter, perhaps in some ways even more than the smaller insurance companies. But maybe their direct to person consumer protection program isn't as significant, and they might not need to have a whole fleet of people in the back room working on consumer protection because they don't have a consumer. And so I don't know that legacy is always the best way. The fact that the insurance company has worked great for the past several hundred years doesn't mean that we don't want to innovate. And that is my concern. And we've talked about this before, obviously, on the select committee with protecting the status quo. That assumes that the status quo is the best way for the consumers and the public and the people and business and industry. I know it's perfect for folks that you represent, but how can we foresee all of the possibilities in the future and anticipate what is and isn't going to be best?
Mr. Chairman, I'm not sure if I have an answer to that question. I don't think that any of us have a crystal ball, or statutes like this wouldn't be necessary, but it's just the position of the client, that you consider not waiving those financial solvency and the participation in the guarantee fund to ensure that protection. But I don't have a crystal ball, so I'm sorry, Mr. Chairman, I don't have an exact answer to your question.
That's all right. Thank you.
Thank you.
That's all right. We're going to have to cut off and go. They gave us till 2:30, but we do have a bill.
Mr.
coming
Chairman,
up
can we
2:30.
see if we have anybody that's not going to be able to come back next time and maybe get their testimony very quickly? We might not. I don't know if.
I don't think so.
Is there anybody that can't come back on, what would be Wednesday?
Wednesday.
Yeah. On Wednesday at noon?
All right.
All right.
All right.
Thank you.
Then we'll continue public
pause.
comment on Wednesday, and we'll move to the